When you plan, you're going to have your financial affairs in order. You, your stuff, and your loved ones are going to be protected. You personally are going to feel good. Your stress will be relieved because you know that you've taken care of your family and estate. Gain peace of mind and have confidence that you and your family are protected. Today you'll discover how to control who gets what, when, and how without probate. How to protect yourself and your stuff during your lifetime. How to avoid costly, devastating planning mistakes. This is for you if you're curious about planning, know that planning is important but don't know where to start or what to do, frustrated with the thoughts of putting your family through probate, worried about the future and security of you, your spouse, your family, or your money, concerned about who will help you when you need help the most, want to know what's in a plan and why, and many more. Imagine you could wave a magic wand to control who will get what, when, and how without probate. Protect yourself, your family, and your assets during your lifetime and beyond, and avoid catastrophic, expensive mistakes. How would that make you feel? How much peace of mind and confidence would you gain? That's what I'm going to show you how to do today. Let me ask, if you don't do anything, in 6 months, will you still be worrying about this? Will you be frustrated because you haven't got around to it? Will you be disappointed because you're not protecting you, your family, and your money like you should or want to? Gary helped us get our affairs in order before our trip to Israel. It gave us peace of mind knowing everything was taken care of for our family. Gary is so easy to work with. We could not have been more pleased with him and his lovely wife, Winnie. We highly recommend DeWitt Law Firm for all your estate planning needs. When I was 40 years old, my dad passed away unexpectedly. Mom and I had to struggle through the rigors of probate. Neither of us had ever done this and were lost, confused, and worried for the entire time it took. Dad had a little money in a lot of places, and we had to find all of it. We had to find all the property, catalog it, inventory it, and then distribute it. All of this had to be done under the oversight of a judge and the attorney. And the attorney was billing us for every minute of time. Then later that same year, I was hospitalized with chest pain. Fortunately, it wasn't a heart attack, but it made me take a good long look at my life. And while I was laying there in the hospital bed, I was worried about the future of my family. I was worried about both their financial security and their personal future. I was also worried about who would make my decisions if I took a turn for the worse. So laying there in the hospital, I knew there had to be a better way to do things. So I made up my mind then and there to go to law school, become a lawyer, and help people avoid probate and worry less about their future, their family, and their money. And that's just what I did. I went to law school at 40 years old, learned as much about estate planning and elder law as I could, and opened my practice to help you get peace of mind. Furthermore, I completed an advanced law degree in estate planning and elder law to better help people. After finishing, I knew how to help people avoid probate, control their destiny, and get peace of mind. I wanted to help people, but they were afraid if they called I would send a bill, so I decided to practice in a different way. I decided to find a new way of working with clients to plan for their future so when they needed me, they wouldn't have to worry about getting a bill. Now clients can call me whenever they need to. Now I work with people like you every day to protect them, their family, and their assets so they can get peace of mind knowing that they have taken care of everything they can take care of. And they don't have to worry about calling later with questions because I'm not going to start the clock to create a bill. That's why I created Epic Estate Planning. It's different. To start with, we guarantee our quoted fee. No matter how much time we put into your plan, the fee won't change. We also guarantee your meeting to start on time. If it doesn't start within 15 minutes of your scheduled time, I'll give you $50. I love this place. Top shelf legal help for wills, estates, trust, etc. They're hardworking, approachable, caring people with their clients' best interest in mind. I'm teaching this because first I went through my father's probate. I think nobody needs to put their family through probate and more, and I love helping others. Today I'm going to cover how to manage your stuff so that it goes to who you want, when you want, and how you want without government interference or oversight, avoiding the costly, time-consuming, complex, expensive, emotional process of probate, how to protect you, your family, and your stuff during your lifetime and beyond, and how to avoid devastating and costly planning mistakes. First, let's talk about how to control who gets what, when, how much, and avoid probate too. 3 important things to keep in mind. First, if you do nothing, the government and legislature have already decided what goes to who, when, and how. It will happen under a judge's strict oversight and may require multiple trips to court. This is called probate. Probate is an unnecessary public evil. Second, wills alone don't prevent probate. Wills require probate to be validated and activated. Probate requires laws created by the legislature and enforced by impersonal judges. Probate is public, complex, expensive, and inefficient at passing property. Wills are created just for probate and require probate. Some lawyers call having just a will your down payment on probate. Third, wills provide no lifetime protection. Lifetime protection comes from planning with things other than wills. If you become incapacitated, even temporarily, during your lifetime, your family may be forced to go to court, often multiple times, to get permission, a guardianship, to make decisions and manage your affairs. Guardianship is often embarrassing and is always public. I want to take just a second to tell you about the image on this page. That's Shakespeare's last will and testament. Wills do 3 things in general. A will is really nothing more than a list of instructions on how to pass your property to the next generation and nominating somebody to care for minor children. It also names somebody to oversee taking the document through court, the executor, to manage the property until its final distribution. A will names who you want to raise your minor children. A will controls who gets what, but not when and not how. It may end up that everything is sold and the money split. A will alone does not prevent probate or a judge's involvement and oversight. A will requires probate to be validated and activated. A will plus some additional planning will prevent probate for your major property, leaving only the little stuff. And Arkansas has a way to pass small probate estates without the need to go to court in many cases. However, the rules around the small estate are strict. The major reason they can't be used is that you owe final medical expenses or credit card debt. You can be very detailed in the instructions, or you can be very terse in a will. I've seen wills from 1 to 40 pages depending on how detailed they were. Wills require probate to be validated and for the property to be passed out. That's right, wills require probate. Wills are just the instructions to the probate court. Keep this in mind. A will can create a trust. This is called a testamentary trust, and they have their place in planning, but it still requires probate. A will does nothing during your lifetime to protect you, your money, or your rights. In order to avoid most probate with a will, you need additional planning. The goal with a will is to get as much of your estate passed outside of probate as possible and use the will as a catch-all for anything else. Your will should just cover the little stuff if there's anything at all left outside of probate. Your major property should be set up to pass outside of probate. Bill thought that just a will would prevent probate, but just a will doesn't prevent probate, as Bill's family discovered when they tried to sell his house. Instead of being a smooth, quick transition, Bill's family had to go through the expense, time, and hassles of probate to get the house sold and estate settled. If Bill had done some additional planning, his family would have avoided probate to sell the house, saving time, money, and emotional turmoil. Before explaining exactly what a trust is, I need to define a few terms. The person creating a trust is called the trustor or grantor. Grantor simply means they granted property to the trust. The person who legally owns the property and manages it is called the trustee. The person who gets the benefit of the property is the beneficiary. A trust is a contract between 2 people, the trustor or grantor, and the trustee, for the benefit of a third person, the beneficiary. A living trust is created during your lifetime. A testamentary trust is created in a will. The most common type of trust used in estate planning is the revocable living trust. Revocable means it can be changed during your lifetime. Living means you set it up now. With this trust, you are usually the trustor, trustee, and beneficiary during your lifetime. However, if you should become incapable of managing the trust property, you have already named somebody else to step in and manage it, your successor trustee. The trust owns your property and you control the trust completely. Therefore, you control your property. When you pass, the trust usually becomes irrevocable and its instructions are carried out by the trustee you've named without probate. The advantages of a trust is the trust property is managed during your lifetime and probate is avoided for all property in the trust. Trusts in Arkansas are not required to pay your final expenses, which can save your heirs literally hundreds of thousands in final medical bills. Trusts give what you want to who you want in the amounts you want when you want under the rules you create. Trusts provide some lifetime protection without a judge's oversight. Trusts usually have a backup trustee to manage the assets in the trust. But that trustee can only manage trust assets, not your other affairs or healthcare matters. Trusts do not require probate. This picture can help you understand better what a trust is. A trust is really nothing more than a contract between a grantor and trustee for the benefit of a third person, the beneficiary. The grantor transfers assets to the trustee. The trustee manages the assets for the benefit of the beneficiary. The most common trust to prevent probate and manage assets is the revocable living trust. With that trust, while you are capable, you are the grantor, trustee, and beneficiary. The trustee owns the property and you control the trust. Therefore, you control the property in the trust. A trust gives you the ability to decide who gets what, when, and how. For example, you can pay out money in the trust at ages 30, 35, and 40, but pay for college. You can pay for rent, utilities, and food for a child with an addiction. Trusts give you the best chance of avoiding all probate and leaving the property to your children without having to pay final medical expenses or worry about other debts. You can go to the bank and name the people you want to receive the money in your accounts. This is called payable on death or POD. However, the money is an outright gift. If the person is under 18, neither the bank will hold the money in trust until they are 18, or the court will order a trust to hold the money until they're 18. If they are over 18, then the money will be given directly to them without any safeguards or limits. They are free to squander it as they please. POD provides no lifetime protection, but POD prevents probate. For many investment accounts, retirement plans, and life insurance, you set up a beneficiary to receive the money, avoiding probate. It's an easy way to give money outright to family without probate. However, the money is an outright gift. If the person is under 18, then neither the company will hold the money in trust until they are 18, or the court will order a trust to hold the money until they are 18. If they are over 18, then the money will be given directly to them without any safeguards or limits. They are free to squander it as they please. Beneficiary designations avoid probate, but don't provide any lifetime protection for you. You can go to the Department of Motor Vehicles and name the people you want to receive them. This is called transfer on death or TOD. TOD has some rules. Only one person can be named to get the vehicle, no more than 3 owners of the vehicle. The owner must be an individual, not a business, and you can't have any liens against it. If you meet these requirements, then you can fill out the TOD paperwork and take it to the DMV along with your current title. Don't sign it until you get there. At least at my local office, they want to watch you sign. TOD prevents probate, but TOD provides no lifetime protection. In Arkansas, this is known as a beneficiary deed. In short, it's a deed that simply says, when I'm gone, my real estate goes to whoever's named in the deed. Again, the property is an outright gift for the recipient to do with as they please. If your spouse still lives in the house, they could be evicted. Beneficiary deeds avoid probate. Beneficiary deeds do not provide any lifetime protection. If you have a straightforward estate, then a will and a combination of POD, TOD, beneficiary designations, can reduce your final estate to nothing but the furniture, jewelry, and clothing you leave behind. If you have more than $100,000 of other stuff, then you need to strongly consider a trust to avoid probate. Arkansas has a way to shorten probate and make it a simple process, but the requirements are that your estate is worth less than $100,000, not including the house you lived in, and you have no outstanding debts. It's difficult to not leave behind some debts, especially doctor and hospital bills. That's why you may not be able to 100% probate-proof your estate with a will and other planning, but you can get it down to only the furniture and other little stuff that isn't worth much. However, if you want to be 99.9% certain that your estate can be passed without probate and doesn't have to worry about paying your final bills, then you need to strongly consider a trust. James didn't think he would ever need an estate plan, but in his 60s he developed rapid onset dementia. Because he didn't have a plan in place, his son had to go to court and get a guardianship to manage his property, money, and health care. And when it came time to sell James' house, he had to spend more money, go back to court to get permission to sell the house. And it would have been worse and more expensive if James' daughter had fought the guardianship. Barbara's mother had started buying everything and anything from anybody that was selling. She lost her ability to say no to any salesman. Fortunately, Barbara had a power of attorney in place that allowed her to take control of the accounts and contracts and stop her mother from buying from every telemarketer and door-to-door salesman. Later, when Mom moved to assisted living, Barbara could handle selling the house and taking care of everything else without going to court to get permission. You need to have your own plan to protect property. If you don't write your own plan, you get the government's default plan. Leave it up to our legislature and courts to produce a convoluted, complex system to decide who takes care of people and how their stuff passes to the next generation. To avoid using the government's plan, you need to write your own plan. Writing a plan ensures your wishes and stops the government's plan. You need to create a trust and/or a will. Even with a trust, you need a will in case property is left out of trust. And you need to set up and create the PODs, TODs, beneficiary designations, and beneficiary deeds on all your accounts and vehicles. Gary DeWitt is an incredible attorney. He and his wife Winnie are sincere, down-to-earth people who just want to keep your estate out of probate. Do you know who can legally make decisions for you if you can't make rational, informed decisions, even temporarily? Nobody, not even your spouse. Your spouse does not have the legal authority to sign for you because of marriage. If you don't have a plan, then somebody will have to come forward and ask the court for permission to manage your affairs. Still, their power is limited, and they will end up back in court to ask permission of the judge to do many things, like sell or transfer property. Not to mention that the cost of a guardianship is close to that of a trust-based plan that includes lifetime protection too. You need durable powers of attorney to name the person you want to manage their affairs and limit on that management. You also need a couple of other things related to health care. A durable power of attorney tells others who you want to manage your affairs when you can't. It can be as limited or open as you want. But the more limited it is, the greater the chance you will have to face very expensive guardianship proceedings in court. Now, that person does not have to be a lawyer. In law, there are attorneys at law, lawyers, and attorneys in fact. Attorneys in fact are those people that have the power and authority to make decisions for you. You want to make sure your power of attorney is durable. Otherwise, if you become unable to manage your affairs, the power of attorney stops. With a durable power of attorney, a trusted person will be there to manage your financial and legal affairs. They can take care of things like paying bills, responding to mail, bank, and manage investments. Taking a short amount of time to create a durable power of attorney is well worth the small effort. If you don't have a durable power of attorney, your loved ones may have to go to court to get authority to manage your affairs. We talked about guardianship a little earlier. Guardianships are often embarrassing, expensive, and public. Much like a durable power of attorney, only for health care. It becomes active only when you are unable to make rational, informed healthcare decisions for yourself. You pick somebody to represent you in healthcare choices if you can't speak for yourself. This tells the world who you want to make healthcare decisions when you can't. Without it, the doctors have a list of people they will take advice from, but then they get the final say. An advance directive, also known as a living will, tells your family and doctors your final healthcare wishes. It only speaks for you if you are permanently unconscious or terminally ill and the end is near. In it, you decide what treatments you want and don't want if you're hanging on by a thread and it is quickly fraying. Don't confuse this with coming into the emergency room with an accident and you have a good chance of recovery. A living will is only used in your last days and hours. Without a release, doctors and other healthcare professionals can't share medical information with family and friends. After a mass shooting in Florida at the Pulse and Orlando Hangout, there was mass confusion about the HIPAA laws and what doctors and nurses could share with family and friends. If these people had releases done, there wouldn't have been that confusion and reluctance to talk. HIPAA allows doctors to reveal information when appropriate, but doctors are often reluctant to talk without a release in place because the fine for revealing protected health information could be up to $50,000. You need to have your own plan to protect yourself. If you don't write your own plan, you get the government's plan. And leave it up to our legislature and courts to produce a convoluted, complex system to decide who takes care of you. To avoid the government's plan, you need your own plan. Writing your own plan ensures your wishes and stops the government's plan. Now you need to put together your durable power of attorney, healthcare power of attorney, advance directive, and HIPAA waiver. You need to make sure the power of attorney includes the power to do everything you need done, limits what you don't want done, and includes the proper legalese to make it durable and legal. The same can be said for the healthcare power of attorney, advance directive, and HIPAA waiver. Gary was so helpful when we planned our estate with he and Winnie. Professional, and I can ask him a question anytime. We love Gary and the DeWitt Law Firm. Next, we'll discuss the costly and often devastating mistakes to avoid. Not planning, willy-nilly gifting plan and forget, and doing it yourself. The number one reason estate plans fail is failing to estate plan. There is perhaps no bigger mistake than having no plan at all. Your estate will be subject to the long, expensive probate process. That process has strict rules on how and when your assets are divided up and passed out. If you become incapacitated without a plan, your family will be forced into court to get permission to manage your financial, legal, and healthcare choices. And it could be Adult Protective Services, not your family, that takes over. Without a plan, you will be putting the hassles of probate on your spouse and children. Without a plan, you risk a total stranger taking over your affairs. Without a plan, you don't have a say in how your property will be distributed. Many people think that giving stuff away is the best, fastest, and easiest way to plan. However, gifting does come with its drawbacks. Anything you give away is considered a gift. That includes putting your children on the bank accounts or deeds. Gifts under the law can be subject to capital gains tax. That is, tax on certain things bought for investment, including real estate and your house, stocks, and bonds. When you give a gift of that kind, the recipient of the gift is expected to pay tax on the increase in value. That's called capital gains. What's worse is that the base used for calculating the tax is what you paid for it, not what it was worth the day you gave the gift. For example, you buy a house for $100,000. 20 years later, it's worth $250,000 and you gift it to your children. When they sell it, they will own capital gains on $150,000. 15% of that is $22,500 of tax, and the tax rate goes up depending on their income. If you left them that same house in a will or trust, they would owe taxes based on the day of inheritance, reducing the taxes due. So if it was worth $250,000 the day they inherited, and they sell it for $250,000, no capital gains tax is due. The same goes for stocks and bonds. Imagine some stock you bought for $2 and it's worth $50 now. If you give it to your children, they owe capital gains on $48 a share. Another problem with gifts is they are permanent, and the new owner gets to do with the property as they wish. So, if you give your house to a child, they can sell it out from under you. And there are cases where just that has happened. Mom or dad ends up on Medicaid in a long-term care facility, while the children pocket the money to do with as they please. Putting a child on your accounts can be considered a gift of cash to them. While cash doesn't have a capital gains issue, putting children on your accounts has its own problems. Since they are part owners of the account is available to their creditors and the IRS. That's right. If they get in credit trouble, tax trouble, or lose a lawsuit because of an accident, that money is available to the creditor, IRS, or judgment. Your child also has the right to spend the money for their own reasons. Making gifts can also cause Medicaid issues. Just about anything you give away within 5 years of applying for Medicaid can be counted against you. I see people every week who think putting children on the deeds and accounts is the thing to do. I counsel each and every one of them about the dangers of doing so. Another costly mistake is planning and then forgetting to update, or at least check over your plan from time to time. Every 3 to 5 years, you should take it out, dust it off, and review it. Whenever a major life event happens, you should review and update your plan. This includes POD, TOD, beneficiary deeds, beneficiary designations, and your other planning documents. If you get divorced or married, you need to review the entire plan. Even minor mistakes can ruin an otherwise good estate plan. If drafted incorrectly, a will or trust could have a different meaning than intended. U.S. News reports that people make mistakes when filling out their own forms or online forms. They go on to say that people often get a false sense of security from DIY planning. One of the major things is that many people don't understand the terms and language used in estate planning. And if the documents are not executed properly, they may not even be valid. Online forms can be outdated and invalid, or at least partially invalid. If not worded correctly, those out-of-date forms can be worse than no plan at all. DIY forms may not comply with state law for the state you live in. They may have been done for another state. I've done plans for several people that started planning with a well-known online service only to be confused by the terminology and the complexity of the questions. Legal terms are literally ancient, come from several languages, and can be downright confusing. Did you know some of the terms have feminine and masculine forms? Sometimes the difference comes down to plural or singular. Some of the phrases are terms of art and some are literal. Unless you know everything that should be present in those documents, unless you're familiar with the language and terms of art, it is better to have a professional help. I don't recommend you plan without help, but if you want to try, here's what I suggest. First, think through putting children on deeds and accounts. Make sure you want them to have unrestricted access to your money and real estate. Realize their creditors, the IRS, and lawsuit judgments could take your money and property away from you if you put them on your deeds or accounts. However, I've thought through this for you. If you insist on a DIY approach to planning, I strongly suggest reading a treatise on estate planning. This will familiarize you with the basics of estate planning. Next, become familiar with the case law regarding estate planning in your state. You can review many of the cases in the online databases. In Arkansas, you should pick up a copy of Title 28. Title 28 contains the will, trust, probate, and administration law. You also need to be familiar with the IRS gift and estate tax code. Natalie Choate's book on how to deal with qualified accounts like 401ks and IRAs is very helpful. And a Medicaid primer is highly suggested so you don't run afoul of its many rules. A set of books on custom clauses and paragraphs for trust and wills would be helpful for reference. Finally, get a copy of Black's Law Dictionary to look up the terms. Altogether, this is about $10,000 in books, plus the time to read them. But I've already invested in the books and read them for you. We have used DeWitt Law Firm since coming to Springdale. They walked us through every step of estate planning and what to do when. Gary and Winnie have huge hearts and the knowledge you need to protect your assets. So far you've discovered how to give your stuff to who you want without probate, how to protect yourself during your lifetime, and costly mistakes to avoid. In just a few short weeks, you're going to have your financial affairs in order. You, your stuff, and your loved ones are going to be protected. You, personally, are going to feel good. Your stress will be relieved because you know that you've taken care of your family and estate. Gain peace of mind and have confidence that you and your family are protected. How do I get started? You have two choices, and the choice is yours. You can struggle through this on your own without help, or you can use my proven system to plan your estate. If you do nothing, you choose the state's default plan for your estate. You choose their default plan for the lifetime management of your affairs if you're mentally disabled. You choose their plan for the distribution of your estate. If you act, you get to call the shots. You get to decide who manages your lifetime affairs privately. You get to decide who gets your estate, how they get it, when they get it, and what they get. Epic estate planning was developed to streamline the process and make it as easy as possible on you while creating a high-quality plan for you and your family. One of the most exciting aspects of Epic estate planning is that I guarantee the fee I quote. No matter how much time I spend working on your plan, the fee won't change. You know ahead of time exactly how much. EPIC stands for Evaluate, Produce, Implement, Calm. We evaluate your goals and talk about your wishes to produce a unique, complete, customized plan for you and your family to ensure your wishes are carried out, prevent probate, minimize family fighting, and reduce taxes so we can implement your plan to make it legally binding and fund as needed to calm your nerves and give you peace of mind. The first step in an EPIC planning session is to evaluate your goals and wishes by talking to you in a 1-hour meeting. Your Family Resources Objectives Meeting. FROM. Why is it called FROM? It helps you move from disorganized and no plan to organized and planned. It helps you move from the government's default plan to your own customized plan. It helps you move away from probate to an easy transition. And in this meeting, you get a 1-hour consultation. Unlike the typical 15-minute phone consultation, you won't be rushed to get your questions answered and then pressured to sign up. Everything we discuss during this hour is completely confidential. What is said in my office stays there. You're going to get 60 full minutes of my undivided attention to go over your goals and wishes, answer questions, and outline the plan that is best for you and your family. It really takes about an hour to get this done, for us to get to know each other, go over your goals, understand your family dynamics, and outline your plan. During this time, I'll do my best to educate you on your options and what they mean. However, if you have any lingering questions after our meeting, feel free to pick up the phone and give us a call. Once this meeting is done, you have the choice to shake hands and leave without obligation or continue to create your personalized plan. Normally, it's $2.25 an hour for my time, and some lawyers would charge you for the initial meeting. I've been there and done that. Not only do I have a family to protect, I have the family farm I've had to plan. In addition to a law degree, I received an advanced law degree in estate planning and elder law. Many hours have been spent streamlining and simplifying the planning process so that you don't have to spend an excessive amount of time on your side. Also, experience has shaped and guided my document creation. I stand behind what I do. I know my stuff stands up in court because I followed it through in many cases. And speaking of court, I also do probate work, so I know what you need to do for your family to avoid probate and simplify things for your family and loved one. The cost of attending those classes and gaining that experience was quite high. I wrote the book, The Definitive Guide to Estate Planning, to educate you in an easy-to-understand way in the comfort of your own home. If you don't already have it, I'm going to make sure you go home with a printed copy. And there's more. Once you complete this organizer, you will have your financial house in order. All you need to do is fill it in. 90% of the hard work has been done for you. This is all the information needed to complete your plan. Also, you will have all the information your family will need in one easy-to-find location. A lot of time and effort has gone into making this organizer complete and easy to fill out. But wait, there's more. Also known as a living will, this document describes what treatments you want or don't want in your last hours if you can't make those decisions. I'll make sure you go home knowing how to fill it out and what is required to make it legally binding. Let's go over everything you receive when you act today. You're going to get 1 hour of my time. Professional expertise. The book. Your estate organizer and a living will, which has a total value of $882. What would it be worth to you to have your financial house in order, and know that you and your loved ones are going to be protected, and that you personally are going to feel good. Having your stress relieved because you know you've taken care of your family and everything you can take care of. What is peace of mind worth? The total value of this consultation with everything you get is over $882. But you can work with me free of charge because you've taken the time to watch this and you're serious about moving forward. My personal guarantee. Your time's important. If your appointment is more than 15 minutes late, I'll give you $50. We guarantee the fee we quote. No matter how much time I put into your plan, I will never charge you more than the fee I quoted up front. Call 479-717-6300 now to book your appointment. The phones are answered 24 hours a day, 7 days a week. Or visit planwithgary.com. Remember, you're going to get a 1-hour appointment in a relaxed environment, my professional expertise, your questions answered, the estate planner, an advance directive, and my personal guarantees, free or for 3 payments of nothing. Call 479-717-6300 now to book your appointment. Our phones are answered 24 hours a day, 7 days a week. Or you can visit www.planwithgary.com. Remember, you're going to have your financial affairs in order. You, your stuff, and your loved ones are going to be protected. You personally are going to feel good. Your stress will be relieved because you know that you've taken care of your family and estate. Gain peace of mind and have confidence that you, your family, and your stuff are protected. Call 479-717-6300 now to book your appointment. Our phones are answered 24 hours a day, 7 days a week. Or you can visit www.planwithgary.com to book your appointment online.